You've heard the old tale, mail your creation to yourself, and bam, you got a poor man's copyright. But is that really a thing? Let's clear all this up once and for all. I'm Kyle Siegel, business exec, entrepreneur, and award-winning intellectual property lawyer. I created this channel to help creators and entrepreneurs make smarter moves around intellectual property or IP. Whether you're launching a product, building a brand, or growing an audience, IP is one of the most valuable things you'll ever own, and understanding how it works can give you a serious edge. But let's be real, legal content is usually boring, complicated, and full of insider jargon.
I am the esteemed Arthur P. Willingham.
This channel's different. You'll find plain English, quick-hitting explainers to boost your awareness and up your IP game.
Verily, pursuant to Title 17, Section 408 of the United States Code, one may, upon due compliance...
Nope. Shut the law book, Arthur. No stuffy lawyer talk here. Look, this isn't legal advice, and no, I'm not your lawyer, but this is smart, digestible info to help you unlock the full potential of your creativity and innovation. So subscribe, hit the notifications bell, and let's go.
Onward and tally-ho!
Here's the deal. Copyright is automatic. The moment you create your work in some physical form like typing, drawing, handwriting, recording, including saving a digital work on a computer, congrats, it's copyrighted. No mailing required. Before we go any further, it's time to smash that like button, hit subscribe, and turn on the notifications bell. Back to it. The poor man's copyright is basically mailing your own work to yourself to get a sealed envelope with a dated postmark is proof that you created that work at least as early as that postmarked date.
And there you have it. All the proof you could ever need.
But in reality, it adds almost no legal advantage. It's not a substitute for registering with the US Copyright Office.
Once one sealed one's opus with wax and parchment, alas, such rituals are relics of yore.
Plain English, you already have rights at creation. That envelope doesn't boost them.
Oh, come now, you simpleton. Surely you don't contend that the mighty envelope has no standing at all in a distinguished court of law?
Look, if there's ever a dispute over who created a work first, a sealed, postmarked envelope might be a tiny breadcrumb of evidence in a bigger pile of evidence. Think drafts, emails, cloud backups, witnesses. But it's weak and it's easy to game. Plus, today, a lot of work is created or recorded digitally, so files already carry timestamps and metadata that usually tells a clearer and more reliable story than a mailed envelope. Back in 2000, this guy tried to extort New Line Cinema by claiming he had written the original script to the movie The Cell starring Jennifer Lopez, and he tried to use a poor man's copyright to do it. When the court looked at these issues, it basically said, this is super shady, and it actually called the guy's poor man's copyright bogus. If you want the strongest tools, like a super easy way for courts to get you paid if someone ripped you off, register your work with the Copyright Office. That's the real upgrade. Plus, you need a copyright registration in order to sue somebody if you want to stop them from infringing your copyrights. Or you at least had to have applied for a copyright registration and had the Copyright Office say no. That's because the federal courts basically say, hey, Copyright Office, you're going to be our filter for looking at copyright disputes. So before somebody can file in federal court, you have to take a look first, Copyright Office.
Hark, creators, and memorize this well. United States Code, Title 17, Chapter 4, Section 412 provides that...
Settle down, Arthur. I got this. Look, register your work within 3 months of first publishing it or before anyone copies it, and you'll give the court the ability to point to a nice, easy number and get you paid. If you wait, you'll likely have to prove how much you actually lost as a result of being ripped off. And that is not always easy. So if you plan to register your work, try not to wait too long.
Pray do not subscribe to this half-wit. He gives you half measures. The real knowledge is here in the ancient tomes of the law.
Bottom line, the poor man's copyright is a myth. Create the work, you already hold rights. Mailing it to yourself doesn't change that. If you want real enforcement power, register with the Copyright Office. If this plain English, no legal jargon explainer clarified things for you, like, subscribe, and comment below. Which IP myth should I bust next?
And as for me, I have the honor to remain your most humble and obedient servant, Arthur P. Willingham.
Bye, Arthur!